meeting of Panel A of the Medical Board of California. We're here to work on 3 matters. I've all been given notice of the hearing which specifies the amount of time that each side has. That will be strictly enforced. The first matter is Ki Sung Che, MD, board case number 800-2015-012-414. I'm Ralph Dash, Administrative Law Judge with the Office of Administrative Hearings and a member of the Medical Quality Hearing Panel assigned to preside over these proceedings. The first order of business is to determine whether there is a quorum present. I would appreciate it if each of the panel members could in turn state their names. Starting from the far right, Dr. Yu.
Felix Yu.
Michael Bishop.
Ronald Lewis.
Jamie Wright.
Randy Hawkins.
David Wormuth.
All right, we do have a quorum, so we are ready to proceed. Any questions on the procedure?
No, sir.
All right, we start. Right now, I have 8:35 a.m. Opening argument by respondent. You have 15 minutes, sir. And please remember, do not go outside the record with respect to your argument. You may begin. Mr. Movana, your state your appearance, please,
John Mulvana for the respondent.
and for complainant.
Nicholas Schultz, Deputy Attorney General.
All right, the notice says respondent goes first. So, Mr. Movana, if you'd like to proceed, 15 minutes.
I will, Your Honor. I thank the panel for coming here today. We're not here to justify the conduct of Dr. Che. He makes mistakes and he accepts those mistakes. His testimony was somewhat inconsistent. The facts that led to his discipline dealt with a conviction of a misdemeanor for spousal abuse. And the second issue that I'll deal with was an offer of $200 to an investigator, which was based upon Dr. Che's Korean culture. We're not here to justify that conduct, but to suggest and request that the board fashion an appropriate discipline short of revocation. I believe Dr. Che will say that this was the worst mistake of his life. From my standpoint, I analogize it to when the criminal matter came to court. He was embarrassed and wanted to have it resolved and accepted this and made certain representations to the police. He pled no contest. He was not disputed. He was fully compliant with the criminal penalties and unsupervised probation. He paid fines of $720. He completed a 52-week domestic violence course.
Speak a little bit louder. I can barely hear.
Okay, I'm sorry. That's usually not said about me, but I'll move this forward. Can I do that? Is that better?
Yeah.
Okay. He is on summary probation. He spent 1 day in jail. The import of that is that he complied with the discipline imposed by the criminal courts, Superior Court of California, and if he was compliant with that, I believe that he would be compliant with any discipline that the board will issue, because I think the board should issue discipline based upon the facts that are in this case. Secondly, regarding the offer of $200 to the investigator, this may be couched by the Attorney General's office as a bribe, but I suggest that it's not for the following reasons. Penal Code Section 67.5 is a wobbler. It is either a misdemeanor or a felony, depending on the amount of money. And it says, 67.5 says that it's a felony or a misdemeanor for any person to give or offer to a ministerial officer or public employee something of value. That's not disputed. But with a corrupt intent, the uncontroverted evidence is that he, as part of his green culture, was intending on paying for gas and travel and lunch. We're not justifying it, we're not saying it's right, but that the issue of intent is missing. My understanding is that the investigators for the medical board are peace officers. If they felt that a crime had been committed, that they would have taken steps to file a criminal complaint and prosecute Dr. Che for violation of that part of the penal code. The last thing is that the intent has to be to influence the officer in its decision in an official capacity. And it's clear that based on the testimony that was at the board that the intent was not to impact the decision, but to compensate him. Dr. Che realizes that's wrong, and I believe that he would say that if you asked him. I also think that you have to look at this in an overall perspective. We all make mistakes, and Dr. Che will agree that he made some mistakes in this case. But if you look at where he sits, his track record, he spent 22 years in practice, primarily treating poor or lower income Korean people, and he provides a good service to those patients. And he would like to continue to treat those patients. And during those 22 years, he has had no discipline. He's had no medical malpractice lawsuits. And I don't know what happened at the hearing. I was not the lawyer at the hearing. And I know that this is not part of the record. However,
Excuse me, counsel, if it's not part of the record, then please do not argue it.
I think that I have to say there's an option to send part of this, the mitigation evidence that was not admitted back to the administrative law judge for hearing on those issues on matters that were extant and were not admitted. And I think that's all I'm going to say, because I'm not going to go into the content, but there were significant mitigating circumstances and character witnesses that either their testimony and their written statements were not admitted. So I think that there's evidence out there to show that Dr. Che is of the type of character that the board would like to have him continue to practice. And so the recommendation of the administrative law judge was for revocation. And I think that the truth and the evidence that was admitted is something that, if you take that into consideration, should resolve or request that result in a discipline that would be appropriate but short of revocation. Additionally, I believe that this is the first time we've had a Korean translator. I believe that Dr. Che's ability to communicate in his native Korean language was missing from the hearing. And also said that's not an excuse, but I wanted to make sure that he fully understands what's happening here today. And in terms of the available penalties, I'm sure the board is well aware that there's lots of things that can be done. I put some into my brief. I don't know if everybody has my brief, but if not, I think that the discipline can include a stayed revocation education with 5 years probation, community service, professionalism at its course, psych exam, medical exam, hospital treatment, all the standard conditions. And if the board thinks it necessary, it could include a sole practice probation, who's practiced by himself now, or actual suspension, 30, 60, some odd days. But I think that the board should, and we're asking, to fashion a disciplinary order that allows Dr. Shea to maintain his license and to aid him in rehabilitation to 2 goals. I think the public is protected and Dr. Shea's license will be protected in a disciplinary order that can be workable for local board and Dr. Shea. Thank you.
Thank you, Counsel. Do you want to respond?
Yes, Your Honor, thank you, and good morning again. Again, my name is Nicholas Schultz, Deputy Attorney General assigned to this matter. My understanding is that this panel has some concern with regards to whether revocation of Dr. Che's license is the appropriate disciplinary outcome. I prepared an argument to that effect, but before I go into it, I'd like to ask if any member of the panel has a specific question or a specific area of concern that you'd like me to address at this time. Okay. Seeing none, I'd like to make clear from the beginning that our position is that the clear and convincing evidence before the tribunal today establishes that revocation of Dr. Che's license is not only appropriate, but necessary to adequately protect the public. And that is given the fact that throughout this process, Dr. Che has demonstrated poor judgment, poor character, and a lack of adequate insight and understanding and acceptance of the wrongfulness of his conduct to ensure that he does not pose a risk to the public health, safety, or welfare. And I will note, as opposing counsel mentioned, Dr. Che has a history of treating low-income patients, and I would submit to you that that is a more than usual high vulnerable patient population. With regards to the first cause for disciplinary action, I think that to understand why revocation is the appropriate outcome, we have to look at both the facts underlying the domestic violence arrest, as well as Dr. Che's explanation and subsequent conduct. To be brief, November 24th, 2014, approximately 9:30 that evening, law enforcement with the Los Angeles County Sheriff's Department was dispatched to Gospel Medical Clinic. That's where Dr. Che and his wife worked at the time. They were dispatched after receiving a report from Dr. Che's sister-in-law that he had punched and kicked her. They were dispatched out there. They interviewed the sister-in-law, and she also reported that Dr. Che had to be physically restrained by another family member, that family member had to intervene to stop the assault. When they went back to Dr. Che's residence, they interviewed other members of the family who corroborated that statement. They also had an opportunity to interview the victim in this case, Dr. Che's wife. They saw that she was sobbing and had redness and swelling to the side of her face. When they asked her what happened, they said that Dr. Che punched her twice because he was upset. Now, by way of background, it turns out at the administrative hearing, Dr. Che testified and he explained the cause for that argument was that he had an elderly aunt that he was very close with, visiting from Korea. Apparently, the sister-in-law had made a comment or suggestion that she should leave before she was scheduled to leave, and he found that to be both rude and disrespectful. Amidst the investigation, Dr. Che was detained and interviewed, and during that interview, he said unequivocally that he did punch his wife because he was upset. Now, that culminated in January 2015 in his conviction for violating Penal Code Section 273.5, Subdivision A. And by way of background, that provision of the Penal Code prohibits the unlawful and willful infliction of corporal injury resulting in a traumatic condition upon his spouse. And Dr. Che did plead no contest to that. And I submit to you that if Dr. Che were here today or at the hearing to suggest, own up to what he had done and to say I've learned from it, I would agree that imposition of probation is appropriate. But what happened next is crucial. In February of 2016, so a little more than a year after his conviction, Dr. Che was interviewed at the HQIU district office in Cerritos, California. Similar to what he had reported to law enforcement, he denied punching or kicking his sister-in-law. He admitted to pushing and pulling her, He did, however, admit to unprovoked physical contact. He, however, at this time adamantly denied ever punching, kicking, or striking his wife. Instead, his story evolved in a manner to make him look less culpable. His story evolved to suggest that when the argument broke out at his home between him and his sister-in-law, Dr. Che followed his wife to Gospel Medical Clinic because she had fled from him amidst the fear of, I believe Dr. Che described it, his blame or his anger. Dr. Che told the investigator that when he arrived at the clinic, he contacted his wife outside of the clinic, and a verbal argument ensued. Instead of punching or striking his wife, Dr. Che said that what he did was push his wife in the back of the head, and as a result, she fell into the car door frame, presumably the vehicle that she had driven there. And Dr. Che insisted he didn't know the cause of her injuries, but he suggested that he believed it was when she struck the car door frame. Ladies and gentlemen, that's significant. Right there we see a pattern consistent with domestic batterers of minimizing their misconduct and trying to separate themselves, or distance themselves from the underlying misconduct. Now, and I should also note that Dr. Che similarly denied having a family member intervene to stop the assault of the sister-in-law. Now, at the administrative hearing, I think we see the most important evidence and the most insightful with regards to why revocation is appropriate. Now, out the get-go, Dr. Che testified under oath that he was truthful with both law enforcement and with the investigator. And he told a story very similar to the one I just described with regards to the subject interview, that he had gone to the medical clinic to find his wife. I had an opportunity on cross-examination to confront Dr. Che with his admission to law enforcement that he had struck his wife. And he said initially that he didn't make that statement. When I pressed him further, he began to recant and said, "I don't know, I don't recall." Ultimately, he conceded on cross-examination that if in fact he had told law enforcement that he punched his wife, that would be a lie. But even more interesting than that, I did something fairly out of character. I asked Dr. Che an open-ended question, and perhaps the most insightful throughout this entire record before you. I asked Dr. Che what he had learned from the incident. And admittedly, Dr. Che mentioned a couple good things. He mentioned he had learned to control his anger by breathing exercises. He had learned to avoid situations that make him angry. But if you refer to the record, you will find that Dr. Che said, unprompted, "I also learned to, quote, never let your family call the police." And that is incredibly insightful. Dr. Che elaborated on redirect examination that he also had learned to forgive his sister-in-law for calling law enforcement and causing all of this trouble for him. And I submit to you the problem with those sets of statements are that even a year and a half after his criminal conviction, Dr. Che's focus is still upon how the situation impacted him, not upon how he overreacted in an inappropriate manner to perceived rude comments and inflicted physical injury upon the persons closest in his family. He didn't focus on the fact that his actions brought shame to the profession. Instead, his focus was upon himself and the effects that it had. And I'll come to this point more later, but there is one other important consideration at this juncture. Opposing counsel was asking for imposition of probation and citing the fact that Dr. Che had successfully completed his criminal probation. However, I remind you that at this juncture, where Dr. Che is testifying under oath and making these statements, he'd already completed his criminal probation and moved for early termination of said probation. If after completing his criminal probation, he still lacked the insight and still failed to fully accept the wrongfulness of his conduct, it begs the question, what can we hope to accomplish by similarly placing him on probation now with the Medical Board of California? Now, turning to the second cause for disciplinary action, and our position is that there are two separate and independent grounds upon which this panel could order revocation of Dr. Che's license. Similarly, we have to look at both the underlying conduct and Dr. Che's subsequent explanations. At the conclusion of his subject interview with Special Investigator Roman Alvarez, the investigator turned off the recording device and Dr. Che stood up as if to leave. At that point, he removed his wallet, took out two $100 bills, and placed them on the table directly in front of Special Investigator Alvarez, looked him in the eye and said, "This is for you." Now, Before I go any further, opposing counsel suggests that the evidence is uncontroverted in this case, that it was Dr. Che's Korean custom. That simply isn't true. There is competing evidence, both in the form of direct testimony from Dr. Che and the circumstantial evidence presented before you. And for reasons I'll get to shortly, I submit that you do not have and should not accept Dr. Che's explanation. Dr. Che, I'll rephrase, Special Investigator Alvarez at the administrative hearing testified under oath, and he described what happened next. According to the investigator, he told Dr. Che he couldn't accept the money, and Dr. Che said, no, this is for you. My wife told me to give you this money. That statement is very interesting because it's in direct contradiction to what he's now claiming. It also demonstrates, again, a shifting of blame. And it's insightful because what it shows is that Dr. Che, immediately upon doing that, recognized that what he had done was landing him in hot water. And he wanted to offer an explanation, a way out. And that said, it wasn't my idea. But at the administrative hearing, Dr. Che's testimony evolved in an unusual manner. Dr. Che testified under oath that he had referred to the money as lunch money, that he'd specifically told the special investigator this is lunch money. And according to Dr. Che, the special investigator understood that because, again, according to Dr. Che, he replied, no, you take this money and enjoy it for lunch, enjoy it with your wife over lunch. Now, during rebuttal, I called Special Investigator Alvarez back and I asked him point blank, did either you or did Dr. Che ever refer to the money as lunch money? Or for that matter, any sort of token of appreciation for coming a long distance? The investigator said no. I asked the special investigator if he ever told Dr. Che to keep the money and use it for lunch with his wife, and he said no. And ALJ Carla Garrett appropriately found, after reviewing the testimony of both special investigators and Dr. Che, that Dr. Che's testimony was not credible because it was wholly inconsistent with the direct, credible, and favorable evidence that was presented against him at the administrative hearing. What do we discern from the facts of this case? What we can discern is that Dr. Che attempted to bribe the special investigator. And when he was caught doing that, he attempted to offer an explanation that it was his wife's idea. He then changed and tried to suggest that it was a result of his Korean culture. And I will note one more important fact, and that is that the first mention that the money was for any reason other than a bribe came in August of 2016, 6 months after his subject interview. And I'll note for the record that that's when the accusation had already been filed, Dr. Che's counsel had received discovery, and settlement negotiations had led both parties to believe that the case was heading to an administrative hearing. And it was only at that point that Dr. Che offered that explanation. So, in summation, when we look at the poor judgment exercised by Dr. Che in using physical violence instead of words, in attempting to bribe an investigator, when we compare that to his bad character by constantly changing the novel of the story to benefit himself each and every time to make him look less culpable, and when we look at the fact that, despite counsel's assertions, the fact that Dr. Che still doesn't own up to his conduct by not admitting that he punched his wife, by not admitting what he really did, but trying to bribe the investigator, we find that unlike other situations where a licensee may be before the panel asking for leniency and acknowledging what they had done, unlike those cases, this is a case where Dr. Che is worthy of reputation. I'd like to spend the remaining portion of my time in this segment, assuming I have 1 minute. Thank you. To just respond to the issue of the Korean interpreter. In his brief, Dr. Che's attorney noted that the Korean interpreter wasn't allowed to testify, and with all due respect to opposing counsel, that was not accurate. Dr. Che's attorney indicated that there was an expert, a Korean translator, that he would like to testify as a Korean expert. If you look at the record, what ALJ Garrett said was she had concerns about whether the interpreter would qualify as an expert. Ultimately, without prompting, Dr. Che's attorney voluntarily withdrew that request for that expert to testify. And so for reasons I'll address in my rebuttal argument, Dr. Che has been afforded adequate due process throughout these proceedings.
Mr. Mulvaney, you have 5 minutes.
Thank you. I don't think I'll take all of the 5 minutes other than to answer any questions that may be posed. No matter how egregious council makes these two events, these two events do not, in my opinion, rise to the level of sufficient evidence to revoke outright Dr. Che's license. And I believe if you ask him how he interprets all of this and whether he truly repents and admits that he made a mistake, then that'll have to go with him. But I think that the evidence is not sufficient to show that he attempted a crime. He was convicted of misdemeanor. If you look at a lot of the cases, especially the recommended range of penalties that the board has, that penalties short of revocation is the appropriate action in this case. Thank you very much for affording us the time.
Reply, Mr. Schultz?
Thank you, Your Honor. I'll make my reply brief. To pick up where I left off, both with regards to the Korean interpreter and now counsel's assertion that there is other mitigation evidence that should have been introduced, I would agree with the administrative law judge in this case that that is simply beyond the scope of this panel's consideration. I would note, however, that Dr. Che, as I mentioned, was afforded adequate due process. He had an open hearing before a neutral magistrate. He had a right to counsel of his choosing, which he exercised, and he had the right to present mitigation evidence, which he did in the form of his own testimony. And I'll note for the record that whatever this mitigation evidence is, still has not been disclosed in the Attorney General's office. And I believe that that poses a slippery slope for this panel. What I submit is happening is that Dr. Che is unsatisfied with the outcome of that hearing. He's asking this panel for essentially a do-over, to present additional evidence. And that simply isn't appropriate in a case such as this, when Dr. Che has been afforded adequate due process. And on one final point, and I reserve any time remaining if there are any questions at that point. With regards to the interpreter, Dr. Che was advised throughout the process of his right to a Korean interpreter. And for whatever the reason, Dr. Che and his counsel chose not to exercise that right. Thank you very much for your consideration.
Dr. Che, you have the right to address the panel directly. Do you wish to address the panel?
본인에게는 패널에게 직접적으로 말씀할 수 있는 권리가 있습니다. 패널에게 직접적으로 말씀하시겠습니까? Yes.
All right, first, let me swear the interpreter. Would you raise your right hand, please?
우선은 통역사에게 선서를 하겠습니다. 오른손을 들어주시겠습니다.
Do you solemnly swear or affirm that you will well and truly translate Korean into English and English into Korean during the course of these proceedings?
본 절차에 대해서 본인은 엄숙하게 선서 또는 합격하시겠습니까? 그러니까 한국어를 영어로, 영어를 한국어로 통역하겠다고 선서하십니까? Yes. 네.
All right, would you state your full name for the record, please, and spell each of your names?
기록을 위해서 본인의 이름 전체를 말씀해 주시고 그리고 철자를 말씀해 주시겠습니까? Haesoon Park, Haesoon Park.
Thank you. Dr. Che, would you raise your right hand, please?
본인의 오른손을 들어주시겠습니까?
Do you solemnly swear or affirm that the testimony you are about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
본인이 앞으로 하게 될 이 절차에서 하게 될 증언 내용이 사실이고 온전히 사실이고 오직 사실뿐인 것을 엄숙하게 선서 또는 확약하십니까?
Yes.
All right. Now, since you are assisted by a Korean interpreter, I will instruct the panel to listen only to the interpreter and not to Dr. Che if he happens to lapse into English. So, Doctor, please speak in your native language.
이제는 한국어 통역사의 지원을 받고 있기 때문에 제가 패널에게 지시하는 바 만약에 닥터 체 쪽에서 영어를 좀 말하는 것이 있다 하더라도 통역사가 하는 영어만을 듣기를 제가 지시합니다. 그리고 닥터 체 쪽에서는 모국어로 말씀해 주시기 바랍니다.
그렇게 하겠습니다.
I will do so.
All right, proceed, please.
진행하십시오.
I
In Korean, please.
한국어로 해주십시오.
하고
모든 여기 참석하신 그리고 모든 참석자들에게 앞으로서 잘못을 사과하면서 내가 지은 모든 죄를 제가 인정하고 뉘우치고 그런 절대 그런 일이 없도록 조심하고 나갔습니다.
To all of the members of the medical board here and to the judge, as a doctor, I would like to apologize my mistakes, and all of the mistakes that I've made, I would like to acknowledge them and I regret them. And in the future, I will be careful and make efforts so that these kinds of things will not happen again.
Does that complete your testimony?
본인의 증언 내용이 다 하신 겁니까?
네, that's all.
Yeah.
맞습니다.
All right,
Yes, that's right, that's all.
thank you. I ask the panel members if they have any questions. Dr. Yip,
패널 쪽에서는 질문 있으신지요?
Dr. Bishop,
No.
Dr. Lewis.
Yes, I do. I have a question, number one for Mr. Mulvena.
쪽에 질문 있습니다.
You mentioned, I guess we both of you mentioned, maybe I guess both of you, about the Korean culture and the buying of lunch. And I'm curious where you obtain that official information, or where do you learn about that common, what you're saying, common practice?
I read it in the record and in discussions with my client. I was not the attorney at the hearing. And that was what I was informed, and that's what I believe. But the real information would have come from Dr. Che as opposed to me. I'm not an expert. And I looked at what evidence was there, and I know that there was some discussion about that on the record, and it's in the record, so that's where I bring that up. But I'm not offering it as an excuse. It was wrong, but I believe that it deals with the intent of Dr. Che, which destroys any claim for his intent for it to be a bribe. And so, I don't know if I answered your question.
Yeah, says it is best as you can do, hearing from you. But there's no official research that this is common practice.
I,
You know from Dr. Che.
if I was at the hearing, I would have probably explored that, but I was not. So
Okay, thank you.
I take it the way I got it.
Okay, thank you.
Ms. Wright,
No, I do not.
Dr. Hawkins.
Yes.
And just given the totality of what's occurred, just curious to hear specifically what Dr. Che would do differently. In other words, can you have a do-over or turn back the hands of time? But I would just like to hear what you would have done differently.
That's better to come from the doctor than from me.
Yes, that's what we're addressing, I'm sorry.
Okay, I'm sorry.
체 선생님께서 질문을 하고 싶은데요. 만약에 다시 그 시간으로 돌아갈 수 있다면 어떻게 다시 다르게 행동을 하시겠습니까? 라고 제가 질문을 드리고 싶습니다.
네. 도메스틱 바이런스 리해빌리테이션에서 52시간 동안 교육을 받았습니다. 어떻게 하는지. 첫째로 뱅거가 있을 때는 심호흡을 3번 하고 그 시츄에이션을 피하고, 그래서 남의 말을 잘 듣고 내 고집대로 하지 않고 국내와 전체로서 우리가 사랑을 남 사랑하는 그런 마음으로 사람을 대하며 특별히 내가 그리고 진료를 할 때에도 환자들에게도 먼저 사랑을 한 마음이 있고 진료하는 대응을 하고 있습니다.
Regarding the domestic violence, I received 52 hours of education as to how to do it. First of all, if I happen to become angry, then I was told to have 3 deep breaths, take 3 deep breaths, and try to avoid the situation. And the other people say and not be stubborn. And especially when I'm doing treatment, when I deal with patients too, I was told to be perseverant, to have patience, and to have control of myself, and try to have love when I am being with other people, interacting with other people.
Thank you.
Mr. Warren.
If the panel does decide to have discipline short of revocation, do you have recommendations on the sort of, on what we should do?
I suppose I'd have to answer that question as sort of a yes and no. As you know, our position is that revocation is the only appropriate. I think it's a difficult decision because period of probation, 5 years might seem good. But the other concern, though, is how do you address the fact that Dr. Che lied to representatives of the medical board in the form of the investigators and under oath with the administrative law judge? Is an ethics course alone sufficient to fix that? I would certainly ask for that requirement. So, I mean, I think that everything that opposing counsel said would be more than appropriate, but I think it still comes down to the conclusion, can we accomplish what we seek on probation, or is in fact revocation the best strategy?
All right, and thank you. This will conclude our open session. The panel is going to go into executive session right now. I would remind council that in the event they want to order a transcript of these proceedings, you can see the court order for the appropriate form, but please do that after our executive session. If the room would be cleared, please, so the panel has privacy, and make sure the television. All right, we're back on the record. Next matter on the agenda is Robert Edmund Grove. Grillo. Is a medical board case number 800-2015-015-460. May I have your appearances, please?
Demond Filson, Deputy Attorney General.
Robert Grillo.
All right. Respondent has the burden and the option to go first. Go ahead.
Can I stand? Okay, so I'm appearing here today and to provide my oral argument for why I believe that my license should be reinstated, which I asked for under a probationary period with following up with drug monitoring at random time at a expense of my own. As I'm sure you may have received, you have my written argument that I had sent in. And so what I had basically said in that was that I'm not disputing any of the findings that were found and according to my case, but would like to say that the fault and blame is completely my own, and I have spent much time and effort trying to receive help, drug detox and counseling during that time, which occurred almost immediately after my suspension from UC Davis. I had successfully completed the detox and rehabilitation period. Now, to provide some history and context, my story is not much different than what other Americans have experienced, including having a chronic medical condition that has resulted in many surgeries and has resulted in a chronic pain type syndrome, which originally started where I started to receive the opioid medications from my previous doctors. As many Americans have experienced, they end up not either having adequate pain control or becoming hooked onto the medication like I had done, becoming hooked, and began to change my use of substances. But because of all this, I was very glad and happy to receive detox detox as well as rehabilitation at New Dawn. And I then continued to receive outside help, including attending Narcotics Anonymous meetings. Since that time, I have not participated in any substances. I have continued to study for, which will hopefully be my board examination either at the end of this year or the next year. So overall, as I said, I'm not disputing any of the facts. I did put my patients in danger. I put myself in danger. I put my colleagues in danger in doing so. And I feel great regret and great remorse excuse me, for having done this. I feel as a physician, I should have, in a sense, had better prior knowledge as to what could have happened. And I should have known that. And yet I watched myself evolve into a very horrible state. But thankfully, having received treatment and continuing to seek outside help, I've been doing very, very well. And I hope that my appearance here today would help be a testament to that, given the amount of time and money that it took for me to get here that I don't exactly have, because I have been working, or have not been working. Even when I had gone to the detox and the rehab center, I was trying to secure full inpatient rehabilitation and was not able to receive that through my insurance, despite calling UC Davis and seeing if I could get Dr. Yellowlees, who was my initial psychiatrist, to call and see if he could get a waiver on this. And to do so, he was not able to, and I paid money out of pocket for as many days as I could, which essentially ended up being 2. But then was relegated to outside rehab, which I continued. Now, so what I'm asking for is that the time period in which I have not worked, which also includes immediately after the suspension from UC Davis, even though my license was still active, that these periods from then until now be considered the suspension period that may have been deemed upon for punishment. And as well, I would like to continue with the initial request that I see a doctor and a psychiatrist for evaluation, and then finally to enroll at my expense with chronic drug monitoring. In addition to all of this, I'm willing to and would like to actually help others to understand the situation that I put myself in, as well as perhaps volunteering to give talks at grand rounds or other type venues for other physicians, especially those who not experienced something like this and have oftentimes not had any direct contact with, say, family members or other people who have had this problem. In addition, I would like to make other positive contributions to the community, which would include, if I were to be reinstated, that I would volunteer at local clinics in the Sacramento area for my time, and in addition to seeking gainful employment if I were to be reinstated. Before all of this happened, I was well respected by my colleagues and in high regard, and it really kills me that I betrayed their trust and did what I had done. Overall, the disease of addiction is a horrible one and requires lifelong maintenance, which I am prepared to do and have done. And in conclusion, there's been nothing more important in my life than to become a physician. I've wanted to do so since the age of 5, and there was nothing else I ever wanted to do. And it makes me feel with great remorse and regret for what I had done. So, in conclusion, I would ask for those stipulations that I had just outlined, and to hopefully successfully re-enter the field. That's all I have for now.
Thank you, Counsel.
Good morning. I'll restate my name again for the record. DeMond Filson, Deputy Attorney General. I would like to first thank the panel for the opportunity to present the case before it today. Before I begin, I would like to ask the panel if there are any specific questions that it has in regards to the level of discipline that was ordered by the administrative law judge at the hearing for this matter. None being stated, I think what is very important for this case is that the revocation that was ordered stay, because it's not only appropriate, it is also necessary against Dr. Greal's license. What Dr. Greal needs most right now is time for himself, for personal rehabilitation. During the time of the hearing, and what evidence was being taken by the administrative law judge, one of the findings that the administrative law judge had at the time was that there was no sufficient evidence that Dr. Greal had sustained rehabilitation. That is the record. He has shown nothing short than approximately 1 week course that he took during his residency, and another rehabilitation course that he did not complete to the end. So with that being said, the revocation must stand based upon the record. There's no evidence for the panel that he has sustained any level of rehabilitation. The egregiousness of the facts, even though that Dr. Greal has stated that he does not dispute the underlying facts of which the accusation was based upon, are still egregious. Dr. Greal was a third-year resident at the UC Davis Medical Center in Sacramento, California at the time of his digressions. He was approximately 2 weeks away from finishing his residency at that facility. He has admitted that most or all of that last 30 years of his residency, he used heroin. He bought heroin from a street dealer. He has also conceded that his addiction to this illicit drug affected his ability to treat patients, and it also affected himself. It affected him so bad that on one occasion, on June 18th, 2015, he appeared for his residential tour, and he left without notifying anyone, not an attending physician, not anyone who was supervising him on that day. That left his patients unattended. In fact, he left because he went to another facility to be treated for his own ailments that arose out of his use of the illicit drug heroin. That gave rise to another subsequent day, 2 days later, where he worked during one of his assessments with the program director at the facility, and that director noticed that he was sort of lethargic. He was slow moving, he was slow talking, and he was having difficulty in diagnosing his patients that day. With that presentation to the program director, she requested that Dr. Greal meet with the facility's administrators on June 22nd, 2015. And at that meeting, he admitted that when he appeared before the program director and he was slow moving and slow talking and having problems diagnosing the patient, that he had taken 8 Norco pills just the day before. And yet still he appeared to treat patients on that day. He conceded to a urine test that day, and approximately 2 days after he conceded to the urine test, he had a second meeting, not only with those same administrators, but this second meeting also included the chief medical officer at the facility. And at that point in time, they had already received the results from Dr. Greal's urine test, where it specifically stated he tested positive for heroin and cocaine. Now, what is more striking, and what testimony that we heard from Dr. James Webble, who was there at the second meeting with the administrators, is that Dr. Grayall showed up to this very important meeting, appearing disheveled. He wore a Hawaiian shirt. He wore shorts. It appeared that he did not whatsoever take the meeting serious, even though it included many of the high-ranking administrators from that facility. During that meeting, he also gave information to the administrators that he utilized home brewed poppy pod tea in order to get out. The accusations filed thereafter based upon the concessions that were made by Dr. Grayall, and this case was heard before Administrative Law Judge Carl S. England, who found that he was guilty of unprofessional conduct based upon his misuse of controlled substances. Now, after hearing Administrative Law Judge England had the opportunity to gather information through Dr. Grayall's testimony in regards to whether or not, the allegations and accusations within the charges were true, and he admitted it. He stood up and he said, yes, I did, like he's done today. He said, I did that, I did those things. But the fear that the panel should have in regards to the digressions that Dr. Grayall have admitted to is that addiction is a serious condition. It is a disease that is a personal battle for not only physicians and surgeons, but also for individuals within society. Individuals who suffer from such a disease need to seek help and gain help in order to attempt to fully rehab. There is no evidence, no record that Dr. Grayall has done that. There is no evidence that he has fully participated in a rehabilitation program that would alleviate the concerns of this panel for further digressions while treating patients. Administrative Law Judge England's decisions and findings based upon the hearing were well thought out. They were an honest and fair assessment of the respondent's character and current state. He took time out during the hearing to answer all of the doctor's questions. He explained the process step by step. He also explained the opportunity for Dr. Grayall to present evidence of his rehabilitation, which he has failed to do. Again, as I stated earlier, respondent needs time to rehabilitate himself. Revocation will allow that time. And with that being said, we ask that the panel adopt the order revoking Dr. Grayall's license.
You have 5 minutes to reply.
Thank you. There are a few statements that have been made by Dr. Filson that I do not believe are actually true or consistent with the record. First one is that it states that there's no evidence that I fully participated in a rehab program, having stated that I did it for 1 week and then did not complete after that, which in fact I did. I provided my New Dawn graduation certificate from the rehab, which was approximately 28 to 32 days long, that I had participated in the summer. That I'm not exactly sure why they are stating that there's no evidence that I finished the rehab when I in fact brought evidence that day, which had the New Dawn seal, which is a treatment facility in Vacaville, as well as information to call and verify that I had indeed finished the rehabilitation process. It is true that I have no good way to show that over these 2 years I have made myself better, despite stating that I have. The one reason that I understand it would be hard to say if I had been sober all of this time would be that the lack of drug tests that were taken after I completed the rehab period. Unfortunately, I was in financial basically ruin at the time and was not able to secure drug monitoring for myself at the time. But I did, and when I was at New Dawn, submit to several drug tests, which over the summer of that initial time showed that there was nothing in my system. And I believe their notes are in the record there, which states how I performed at the rehab, stating that I did very well myself, and in fact was helpful to many other patients given my expertise. With regard to the assessment with Dr. Wheelock for my physician in training exam, I don't believe that is in the record, but it may be.
If it's not in the record, then don't argue it.
Okay. So the other statement is that I had taken Norco 8 of them the day before, and it makes it sound like I took 8 of them all at once, which is not the case. And I also did not use them the day before. Granted, during that meeting, it's very stressful and hard to keep exactly the timelines of events, but it was Norco within 2 weeks of that time, which was not taking 8 of them all at once, which would have been quite dangerous for the Tylenol that was in it, in addition to the opioid that is in it. I say that just for a certain clarification of the record. With regard to the meeting with the hospital, I totally understand and take fault for my dress. However, I did take it quite seriously. It was essentially an unfortunate series of events there. I was supposed to be graduating, family was coming, I was going to pick them up, and eventually I was not within time to go back home and change, which I felt terrible about. But I did take that meeting quite seriously and told them about my medical condition, the issues that I had, and had agreed to go see Dr. Dr. Yelovitz with this. Essentially, after a while in taking these medications, you're not getting high, you're just getting normal, which is essentially what had begun to happen to me. I never had intention of getting high. But overall, I agree, yes, this is a disease. And I feel like sometimes when we look at the disease of addiction, we look at it with a double-edged sword, be it you purposely did what you had done, or you could not somewhat control yourself because of compulsion. But I think if we can continue to consider this a disease, and I am able to show after a certain time that I have been clean, can be clean with, as I requested before, being put on a probationary license with random monitoring, that I essentially would have to secure a loan to pay for it, but I will do that. And given a few weeks to a month or two with those random tests coming back negative, I would hope that that would show my continued cleanliness in this matter, as well as the seriousness at which I take this. I've had two years almost at this time, which I would not say is sufficient enough, and I think for anybody, because it is a lifelong struggle, but I have made great strides in staying healthy, seeking alternative pain control that did not require opioid medications, including acupuncture, massage, physical therapy, and braces for my shoulder. What I feel like I need right now to keep me motivated, in addition to just my own health and impact I've had on my family, would be to go back to work. As I said, it was something I love to do and could not live without doing so. And I think if I was allowed to work as well, it would help in my rehabilitation to be a functional, once again held in high regard position. So in conclusion, I would like to say that given all these things that were said, these 2 years have been a great amount of time for me to personally seek mental health as well as physical health, which included exercises and things like that. And I feel like there's not...
Time is up.
Sorry.
Counsel?
Thank you. First, let me address some of the assertions made by Dr. Greyow that there is evidence of his completion of the New Dawn treatment certificate, and that is not true whatsoever. There is a record of his treatment being given at New Dawn treatment centers, but there is no record of his completion of that rehabilitation program. What came out most striking to me in his argument was that he would have to, if given probation in this matter, he wouldn't be able to afford the cost that are associated with probation. And I think that he even said that he would have to be alone in order to participate in that probation program, which is a problem. And this is exactly why revocation should be adopted by the board. It's because he does need time to get on his feet and to rehabilitate himself personally, so that he won't have to take a loan to utilize the probation program and all of the costs that are associated with it. He is still in the process of rehabilitating. So to what level, we don't know, because he has not attended and fully completed a rehabilitation program as of yet. So with that being said, I think that the panel should adopt the previously proposed discipline of revocation in this matter.
Thank you. Before I call for questions, when we tell the reporter there are two names mentioned, Dr. Wheelock, it's W-H-E-E-L-O-C-K. The other is Dr. Yellowes, Y-E-L-L-O-W-E-E-S. Doctor, you have any questions?
Yes, question one, I believe you do have a certificate you can submit for your New Dawn. Two is that are you under the care of a primary care or pain management specialist for your condition, or you mainly just a psychiatrist?
I had received that counseling and treatment at New Dawn Center, which trained me in seeking abilities for alternate pain control, which I have been prescribed in the past, including physical therapy and other alternative measures, including the brace and the acupuncture. Currently, it has been approximately a year since I've seen my primary care physician, but these skills in trying to maintain alternate pain control of my shoulders because of the Ehlers-Danlos syndrome that was there is something that I already have knowledge of from prior training, from having seen my doctor, getting the brace, and so I continue to do that. I do not, at the time, want to see I would see a pain control doctor if that was also felt necessary. But with my initial treatments by my orthopedic surgeons and previous treatments from my primary care physician, really the rest of pain control, especially non-pharmacologic pain control, is up to me. And I have already learned the things that I need to do to help keep this pain under control and not push me back to using opioids.
Do you still have weeks of training to compete at UC Davis to board eligible? You told me.
Actually, no, I don't have any more time to complete at UC Davis. They, given the nature of it being so close to the end and having fulfilled all the requirements already to graduate, they have actually said that I'm graduated and can graduate. And essentially, that is what has happened is I have graduated from there.
Did they give you a certificate that you graduated?
Not yet. I believe I actually can go pick it up, but given that there was a couple more things that I needed to do with them for the Board of Neurology and Psychiatry, which is taking...
I'm concerned you're going outside the record.
Okay. So I guess long story short is, yes, I have completed at UC Davis. And for the next, to take my board exam to be certified, I need to have 2 more supervised physician exams, which are required for taking boards. So overall, yes, I did complete UC Davis, and then personally, those 2 things.
Dr. Bishop?
No.
Dr. Lewis?
Yes, and I might have other questions, so I'll let you know when I'm finished, so we don't go on. I have a comment or a question for Councilor Filson. You made a statement that I'm going to repeat back, and you tell me if this is correct. Because he cannot afford the probationary terms, we must make a decision to revocate. That's what I just heard you say. I'm a little concerned about that statement. Is that correct?
In the context that I meant it, that stating alone probably is stated correctly, but in the context that I meant to present to the panel, is that it has to do with the ability for this doctor to, and for you guys to be able to have comfort in knowing that he's going to be able to fulfill the obligations that are necessary under the probationary period. With knowing that he's not working right now, and I think the record states that he wasn't working at the time, that would be an issue, especially given the fact that he has a history of drug use. In addition to being unemployed and not being able to afford the probationary costs, what he needs is more time. And so I think the context of that statement was that he needs more time, and that's why it's not going to be appropriate for this panel to utilize probation as an option.
It's a concerning comment, and we make decisions here based on public protection, which you agree, not on financial ability. So I just want to clear that up, because I heard that and I was like, okay, let me ask that, but I understand your explanation. Now, I have a question for Dr. Grail. We all agree that addiction is a lifelong monitoring process. But when we look at people with addiction issues, we also look at evidence of commitment. And for me, commitment to hopefully sustain the period of sobriety is length of time in a program. Because the relapse rate, as you know, and we all know, is very high. 85, 95% just relapse all the times. So I'm looking at your period of time in treatment, and if I'm correct, when I read your note, it says 1.5, I think that's right, 1.5 years maybe?
Is that in my personal statement?
Yeah, in your personal statement, I don't get a sense on your current treatment program and the dates.
Yeah, I'm not exactly sure where that is. I think when I was referring to 1.5 years, I was stating the time in which I had not worked and had personally sought.
Okay, so
But
how long have you been in a program? From what dates? And what frequency? Because it demonstrates to me a period of time that I can be reassured somewhat, of guarantees, that there's commitment.
So
That's item 3 of his statement.
Yes, but I'm not understanding it, so can I ask him to clarify?
okay, yes. So this is saying about how I immediately sought treatment at New Dawn once the suspension at UC Davis was made. Again, to reiterate what I had said, I did spend time inpatient for detox, time inpatient for inpatient direct formal treatment, was not essentially able to afford out-of-pocket continuing the inpatient treatment, and did outpatient treatment at New Dawn, which is on Greenback Lane in Sacramento, or Roseville, I believe. And that was all over that summer, from June up until September, when I completed 2 more than 28 days, which is considered the length of the time for an outpatient rehab program. After that time, and during that time, you're also directed to seek continuing care, which could be in many forms, and the one that I had chosen was to attend Narcotics Anonymous meetings. So what I'm saying in that item is that I have been drug-free during that time and have continued to get treatment via, or I should say support via the Narcotics Anonymous group. Like I said, I completed the outpatient to the fullest extent that I could and was satisfactorily discharged from there. When I went to the meeting, the hearing with Mr. Filson and the administrative law judge, I provided my certificate, which they had made a copy of, and kept the original and gave me back the copy. Now, with regard to financial ability to pay, I find it, don't know if ironic would be the right word, but if I'm not able to work, how am I ever going to get money to take the monitor? Now, granted, when I say I would have to take a loan, my family would support me in doing this, and I would do that from perhaps one of my parents. They've been saving up money during this time to do so because my father is permanently disabled from a near-fatal car accident in 1989, and my mom works as a cashier at a food store. So during this time, she's been putting money aside for me to hopefully be able to pay for the monitoring. If not, I will secure a loan to do so, to get me started so I can take the monitoring tests, get to work again, and then with the money I'd be making from working, I'd be able to pay for the remainder of this, however long it may be, monitoring period. But again, essentially it would be counterintuitive or counterproductive, in my opinion, to keep me from working again, because like I said, I just would not then ever get money to do anything, and I feel like not working as time is going on would, and this has been documented with other people, that if they don't get jobs and do things like that, they're going to relapse as well. And I feel that I've done quite a lot over these 2 years personally, going through the steps of NA and doing the physical therapy, that I think what I need now is to work. That will help me.
Edgar, I'm going to interrupt you because my question to you was evidence of continuing ongoing treatment, and I don't get the answer. Can you just answer that?
I guess with respect to direct and ongoing treatment, not with a treatment facility anymore because my insurance I finished the program. So the only ongoing treatment I have right now is continuing with Narcotics Anonymous.
Which you are continuing with?
Yes,
Okay.
yes, several times a week, and I go to many different ones in that area.
That's good, thank you.
I have two. Start with our dad. So generally, when we non-adopt, that means that the panel has some issues with the ALJ decision. I'm sure that's obvious. So I want to just ask you to answer this one question for me. How would you respond if I said, do you think that one cannot be rehabilitated through probation and it's only through revocation? I want you to give me the response other than the financial condition and he needs more time. I want you to hone in on the probation part, and then I do have a question for you, sir.
So is your question, may I clarify?
Yeah.
Is your question, do I believe Dr. Grayoff cannot be fully rehabilitated through probation?
I think it's two parts. Can he not be rehabilitated through probation, and is revocation the only answer? And then generally, is one in a similar condition capable of being rehabilitated through probation?
Well, I will first say that, in order to answer your question, that there has been, if you ask me, I believe that a physician like Dr. Grayoff's position would need to be in a continuous or completed, substantiated treatment center to its completion or currently being in. I don't think that we have any information that he is doing that other than Narcotics Anonymous. That is my concern, because associated with a non-rehabilitated drug user are, the fact that he left his post as a resident at the hospital. When you're on probation, you're going to have to meet with a probation monitor. You're going to have to show up for drug tests. You're going to have to be some level of security in knowing that he's going to be able to follow through with those things. And so I think that probation is not appropriate because there is no evidence of rehabilitation or sustained rehabilitation. The ALJ, in his decision, on the last page of his proposed decision, even stated that respondent failed to offer sufficient evidence of sustained rehabilitation to demonstrate that it would be consistent with the public health, safety, or welfare to allow him to retain his license.
So, let me maybe ask it a slightly different way. The treatment center, it's not possible to obtain that type of treatment through the probationary process?
I'm not sure that the probationary process will provide treatment to a physician or surgeon. I think that they are monitoring a physician and surgeon.
And then, sir, you say in your statement, thank you for that response. I will use my medical license to benefit my community every chance I get. And then I read the several lines you write. To me, that just sounds a little fluffy. Can you tell me what you're going to do to benefit your community exactly if you get this license?
Sure. My experience as an intern at UC Davis was going to the community clinics and meeting the population that's there. And I would like to participate by volunteer method with my local community clinic for indigent services. I believe that would be very helpful to my local society as well as myself and to the physician's office or state medical office. In addition to that, which would not necessarily require my license, but would be to, again, counsel others giving talks like PowerPoint slides at, say, a Grand Rounds or a local physician group to talk about my experience as well as provide information about this disease that I've learned through my time here trying to and getting very much better. Now, what I would say is, how does the prosecution or the other side be able to say, I need more time to get better, which I agree, and it's going to be lifelong, but who is qualified to make that statement? I feel that a physician, psychiatrist, or other person would have to say that, and I've not been evaluated by them yet, which I would like to do. In addition, ongoing treatment, generally, as I understand it, the standard of practice for people who are first-time drug abusers is the detox and outpatient rehab, which I, again, state I did for 28 to 32 days. There's no other, essentially, way to continue to get treatment other than through Narcotics Anonymous at this time, but a kind of formal treatment like New Dawn Treatment Center is not what I would suspect that I should or other patients in my position would have to go back to. That's the initial treatment. And then after that, it's sustained personal growth and outside help via Narcotics Anonymous, psychiatrist, or other, which I would even prefer, if necessary, to see a counselor or psychiatrist again, trying to find financial funds to do so. But again, then with the probation period, putting stipulations on my time, I would of course have to work out a plan with my future employer about having counseling sessions if I were to take them like that, or to have drug monitoring where I would have to take time, which generally I would think would be early in the morning before I would even have to be at work. Because in my position as a resident at UC Davis, there were actually other physicians who were also seeking counseling and on drug monitoring. And I mean, when I talk to them about this, given that they've had the same problem, they say, my color number gets pulled on the website for monitoring, and I go in and I call Dr. Wheelock, he says, to let her know, and they are aware and accommodating of this type of situation. And I would venture to guess that other physicians groups or hospitals would also be sympathetic to this issue and allow me to take my drug monitoring, which, like I said, would probably be in the morning before work, because this is what I've seen others doing, not actually taking time out from the day to go do these things. I think that's all. Did I answer your question?
You did right at the beginning of your comment.
Sorry.
So, I just wanted to remind everybody in the room that what we do is protect the public, and if you have the ability to practice medicine, which almost certainly be in a supervisory fashion, we'd have to feel comfortable that there are systems imposed that allow the public to protect it. I just have a question regarding any way along this process, whether it's the New Dawn program or Narcotics Anonymous. What did you surmise was what you were going to have to do to be able to get the trust, again, of the medical board and the public to be able to have a shingle and say, come into my office, let me evaluate and treat you? Because I'm just wondering, I don't get the feeling, but I let you have give us an opportunity, but perhaps not repeating what you've already said, unless it actually gives us a good picture about, coherent picture about what you believe it takes to be able to get that trust again. And I think you think that if you have a couple random drug tests that you control, it's going to do it. It really is not going to. Or that you may have the option of having a therapist if you wanted to, if you agreed to. That is not how it works either. So give us a feeling about your understanding of what it might take to be able to allow us to feel that you deserve the trust of being able to see patients in almost certainly a supervised fashion.
So for new counseling or treatment modalities, I would have to think that securing counseling with a psychologist, psychiatrist would be a beneficial step in showing the panel that I can be trusted again and I can work confidently. I don't mean to say that a couple of random drug tests being negative would be enough to show that I gain trust, but I would think that it would help lend some weight or credence to that. And with regard to what I thought the treatment was going to go, at the beginning of that, I wasn't exactly sure. I was hoping, I would get as much as I can to show that I really am motivated, be it inpatient monitoring or inpatient rehab, which again, I actually tried to do, paying the last bit of my bank account on continuing a couple of days more inpatient, which I understand is very little, but still then completed the outpatient treatment. I think the way I expected this to go is the way I've seen other patients who have been treated for addiction do, which is, as I mentioned, the treatment initially, in my case, intensive outpatient treatment, followed up by Narcotics Anonymous, like I had been doing and have been doing. This is, in my experience, having seen others go through this is what their treatment mode is like. Generally, when I've talked to others who have been multiple repeat offenders, then generally they are pushed further into rehab or inpatient rehab, given their first, second, third, or fourth failure. I think that besides my sincere earnestness that I am being and have been greatly rehabilitated, and what evidence I was able to provide, I think that, again, showing with those drug tests, not like a week or two, a month more than that, that would help show that not only was I clean, but continue to be clean. And the fact that I'm willing to put myself in further possible financial jeopardy, given the fact that I took out loans for medical school, which are astronomical at this time, I would do that as well.
Thank you. One last question. When did you last use any illicit or prescribed narcotic medication?
That was when I had finished the detox period the day before at New Dawn, given the buprenorphine treatment.
When was that? Give me a date.
July 3rd. It's so long ago. This time, sorry,
A month is
back,
fine. A month and year is fine.
Yeah, right. Pretty much in the beginning of July when I got out of the detox and did the.
What year?
Not this summer, the last summer. So approximately.
July 2015.
Yeah.
Okay.
Mr. Warner?
I
believe according to your statement, you voluntarily gave up your license 23 months ago.
Yeah.
What have you been doing to keep up with the profession?
So what I have been doing has been personal study time at this point in the matter. Like I said, I need to take the neurology board exams, and so during this time, I have been studying for that exam. Unfortunately, having direct patient contact to keep my physical exam skills current, besides practicing on home with friends, which I have done, I can't demonstrate in that way that I've kept current, but again, personally following the news, following new treatments that have come out at the time, and continuing to study has been the most that I have been able to do essentially to keep current. And I would worry that any more time, despite how much practice I would try to keep current, would be detrimental when I finally did get to practice again. So overall, keeping current has been a personal journey. Again, reading through my neurology books, studying for the exam, and studying for my physician supervised examinations, of which I have two left to do before I can become board eligible.
Thank you. That concludes the open portion of this hearing. The panel is going to go into executive session. As I mentioned earlier, you can see the court reporter will give you a form in the event you want to order a transcript of these proceedings. We'll go off the record. Petition for reinstatement of the revoked certificate of Joanne Marianne Benzor. This is board case number 800-2015-016022. May I have your appearance, please?
Deputy Attorney General Trina Summers on behalf of the people.
And would you state your name for the record, please?
Joanne Benzor.
All right, you've been given notice of the procedure for this matter. Opening argument by Ms. Benzor, 15 minutes max. Go ahead.
There are a few statements in the history of my DUI in the records that I'd like to clear up. In several areas, it's stated that I was drinking all day. That's not true. I went out to a new restaurant for brunch with two friends. They didn't have any tables, so they seated us in a bar.
Remove it to the record that was already created.
This is not in the record?
Yes, it is.
Okay.
I'm clarifying the record. Is that not?
Did you present evidence about what you are saying right now?
Yes, it was in several.
If you presented evidence at the hearing on what you're saying now, and you're saying that the judge disagreed with what you said, that's fine, you can argue that. But you can't bring in new facts.
It wasn't the judge who argued that, it was the attorney.
Whoever,
Okay,
as long as it's in the record.
it's in the record.
All right, since I'm not familiar with the record and I don't have it, there's no way I can check.
No.
I'll accept your representation. Go ahead, clarify.
So I was not drinking all day. I was at a restaurant seated in the bar because they didn't have any tables. The waitress was persuasive with her recommendation of a pomegranate martini. I'd never had one. I ordered a second one, and sometime during the second one, I started an alcoholic blackout. I don't remember ordering a third drink. I don't remember my friend putting me in the car and taking me home. He stopped at his house. I don't remember getting into the driver's seat and taking off. I don't remember anything of the subsequent 4 to 5 hours. When I first met the medical investigators, they mentioned my time at the Riverside Regional Hospital, and I questioned that because I didn't remember going to the hospital, but later found out indeed I was. That episode was almost 8 years ago, and I have never had any other bad experience with alcohol before that or since that time. I believe if I had done this right, I would have come in having seen an addictionologist, having letters from coworkers, friends, families stating that they knew of no history of mine indicating that I had
Objection,
substance
Your Honor.
abuse.
What she should have come in with is outside the record.
No, that's fine.
I'm at a
That's strictly
disadvantage here
argument,
because
counsel. Let her finish her argument.
I'm not an attorney and I've been at a disadvantage throughout these hearings.
Just go ahead. Just rule in your
If-
favor. Go on.
If I had an attorney, he or she probably would have had me see an addictionologist and come in with letters from coworkers, friends, families, stating that I had no history of substance abuse. I didn't do that, and what I gather, the board hasn't been convinced that I do not have that history. I don't drink. The reason I went into a blackout was because the martini was equivalent to about 3 shots of hard liquor and hadn't eaten that day. And again, like I mentioned, I have had no prior or recent problems with alcohol. I realize that the board sees the conviction of a DUI as a serious problem, as do I. That it can represent just a lack of society's law and a disregard for the public. I realize that. I am very thankful that I didn't injure anybody. However, I have been injured by that one episode in that I lost my license. I haven't had any good job in 5 years. And I believe that one episode doesn't make me a substance abuser, and I would like to return to the practice of medicine. I have a job waiting. I have the owner of 3 clinics that has saved my job. It'll be the same job that I had when my license was revoked. And he has volunteered to review all of my charts on a daily basis until he's comfortable that I am back up to speed with the practice of medicine. And I think that's a much better way of protecting the public versus the alternative of having a physician monitor who is paid and reviews my charts on a quarterly basis. I think a much better way to protect the public and my patients is to have Dr. Ruiz review charts on a daily basis. I've tried to keep up with changes in medicine, and I'm also relying on my 29 years of practice in medicine. I was always very good with patients like me, I like them. I haven't had any malpractice complaints, haven't had, excuse me, any formal complaints from any patients in my 29 years of practice. The clinic is set up so that there's plenty of help and resources. If I'm not sure of a dose of medication, there's a pharmacist that's in the clinic. For any other information, it's virtually at your fingertips with the internet. There's computers in every exam room and in the doctor's office. And I do not think that I would be a danger to the public by returning to medicine. I haven't been financially stable since my license was revoked, and I would like to return to being productive member of the medicine and return to the practice of medicine. And I believe that the board can depart from their guidelines regarding the DUI and allow me to return without 5 years of probation, body fluid monitoring, etc. Like I mentioned before, it's been 8 years since the DUI. And I think it's time that I return to the practice of medicine.
Ms. Saunders?
Good morning. Public protection is the highest priority of the board, and in considering reinstatement of the certificate, the board must consider whether or not the public would be at risk. And the people suggest that the public would be at risk if Ms. Benzer's license were to be reinstated. Therefore, we urge that the board deny the petition for reinstatement. In October, I was before this panel and argued the same thing. Since that time, not much has changed. The record certainly hasn't changed. And what the record reflects is that Ms. Benzer did not learn from her past misconduct. At the hearing on the matter, she didn't show any recognition that her actions are what led to the downfall of her career. Instead, she blamed others. And I think it's important to point out that while we've heard a little about Ms. Benzer's DUI here, that's not where the trouble started. The trouble started when she was disciplined by the medical board for her failure to supervise PAs and for her failing to take physical examinations of patients, for her pre-signing marijuana recommendations and allowing a physician's assistant to give them out without any examination of a patient, and her herself giving them out without any examination of a patient. At that hearing, she blamed others. She argued that she didn't show remorse, and quite frankly, remorse is the cornerstone of rehabilitation. Ms. Benzer blamed everyone from the board to her finances for her situation. She didn't admit it was her own failure to practice within the standard of care that led us down this path. It was her own failure to abide by the guidelines of her probation that resulted in a revocation of her license. It was her second chance, and she failed to comply with those rules and regulations in order to complete her probation. The record also demonstrates that Ms. Benzer believes that her license should be reinstated without restriction. She doesn't believe she needs training and education. According to her testimony at the hearing, not much has changed in medicine. She specifically points out that her ability to give a good physical examination has not. The practice of medicine is fluid, but setting aside that for a minute, if her assertion is true, her assurance that she can give a good physical exam is not reassuring to the people of this state, as it was her failure to practice within the standard of care, and specifically her failure to give examinations that got us started on this journey. While on probation, Ms. Benzer was unable to comply with the laws of the state. Her license was revoked as a result of a driving under the influence conviction, exacerbated by the fact that she hadn't met other conditions of her probation, like taking the records-keeping course, like paying her probation monitoring costs. Another thing that hasn't changed is the fact that Ms. Benzer has the burden of proving rehabilitation and fitness to practice by clear and convincing evidence to a reasonable certainty. This has not been done. In 2006, the board filed an accusation for gross negligence, repeated negligent acts, failure to supervise, and failure to perform good faith examinations. Ms. Benzer not only allowed a PA to see patients, but allowed the PA to provide pre-signed marijuana recommendations to patients. And she herself gave them out without conducting physical examinations. In 2007, she entered into a stipulated settlement with the board, where she agreed to abide by the terms of that stipulation, including to follow all laws. However, she did not. At the hearing on the accusation petition to revoke probation, Ms. Benzer demonstrated that she didn't appreciate the magnitude of her professional misconduct. She minimized the conduct. When testifying about the incident in which her alcohol abuse was exposed, she simply said she was on vacation when she drank and drove and was not a danger to her patients. She indicated that the incident was a one-time deal. Due to her lack of appreciation for the magnitude of her actions, her probation was revoked. On July 1, 2015, she petitioned to have her license reinstated. She filed a petition packet that consisted of her petition, a narrative statement, 2 letters of recommendation, and an article she authored and had published. In the article, which she submitted for consideration by the board, despite her prior admissions for gross negligence and failure to supervise her PA, in her article she claimed she was only punished because she didn't have the money to hire a lawyer. And in the same article, Ms. Binzer made light of the board carrying out its mission of public protection, saying what are exactly they protecting the public against. The chance that I'll ever recommend medical marijuana to an undercover cop again, 0. The chance I'll ever overdose on martinis again, 0. This certainly doesn't ring of remorse. It instead sounds like the words of someone who believes they were wrong and owed something by this board. A hearing on the petition took place on April 28, 2016. Ms. Binzer was the only witness to testify. She did not come to the hearing on her petition for reinstatement remorseful or provide testimony admitting she practiced outside the standard of care. Instead, she just told us that she knows how to conduct a good physical exam. Despite her prior admission, all causes for discipline, and all allegations contained in the accusation, she attempted to justify the lack of care provided to the patients, stating she doesn't think the gravity of her conduct was as significant as argued by the people. Because there were 5 undercover agents, medical marijuana recommendations were only given to 2 of them. And despite the fact they did not undergo a complete physical exam, she deemed them appropriate patients. She further justified her failures and said that because others at the clinic did not do their job and comply with the standard of care in the community, she thought this should excuse her from doing so. Despite all of this, the board issued a decision after non-adoption, which allowed for the reinstatement of Ms. Benzer's license, subject to a number of terms and conditions. Ms. Binzer did not accept the terms of the board's decision after non-adoption, which led us here today. What Ms. Binzer has demonstrated in the papers filed pursuant to the board's grant of reconsideration is that something else that has not changed is that she still doesn't accept responsibility for her actions and refuses to understand that more than her word, which has proven unreliable in the past, is necessary to ensure the safety and welfare of the public. In her written argument regarding this, she blamed the clinic that she worked for her decision to practice medicine with disregard for the standard of care in the community. She states that during the time she provided substandard care, she worked for an atypical clinic and followed the clinic's protocols, and contrasted this to when she worked for typical medical clinics, saying that typical clinics gave exemplary care, and she never got a complaint when she worked there. If anything, this excuse suggests to the people that Ms. Binzer practices medicine at a level to get by. This in itself demonstrates that she's not ready to hold a physician and surgeon's license. And if she does, in order to ensure that Ms. Binzer practices safely and abides by the rules and regulations of her licensing agency, she would need to be closely monitored. In that same briefing to the board on April 6, 2017, Ms. Binzer goes on to further explain that she's sorry that she placed people at risk of harm by driving under the influence. However, she expresses she doesn't feel the need to undergo any psychiatric evaluation, be mandated to abstain from alcohol, or be subjected to biological fluid testing to ensure that she does abstain from drinking. It appears that once again, she's suggesting that her self-diagnosis and her word should be enough for this board and for the people to be satisfied that she can safely practice medicine without placing the people of this state in jeopardy. Ms. Binzer argues that due to the financial burden it would place her in, she should not be required to have a practice monitor, and asks the board to sympathize with her financial condition and reconsider not only that, but its decision to require her to participate in a clinical training program. If Ms. Benzer's license is to be reinstated, such conditions are necessary. The fact that there are financial burden does not outweigh the need for these conditions to ensure the public safety and welfare. The board is charged with evaluating Ms. Binzer's evidence of rehabilitation against the criteria set forth in Title 16 of the California Code of Regulations, Section 1360.2. Once again, the people have evaluated the evidence Ms. Binzer presented alongside the criteria set forth therein. The section states that among other things, one ground for denial of a petition for reinstatement is the nature and severity of the acts and crimes under consideration. While Ms. Binzer has made light of the actions that led to her license being placed on probation, we find that her actions with respect to medical care provided are significant. We also find that Ms. Binzer driving with a blood alcohol level more than 2 times the legal limit is significant and shows poor judgment. Another criteria to be considered is the time that has lapsed between the commission of the crime. A significant time has passed since Ms. Binzer's license was first disciplined and since her DUI. However, what is disturbing and alarming is that her attitude has not changed, despite the lengthy time she's had to reflect on what happened. Another factor to be considered is evidence of rehabilitation. Ms. Binzer submitted her evidence of rehabilitation with her original petition. She submitted the article that I mentioned earlier, where she doesn't take responsibility and blames others, and asked the board to consider that article, and not the fact that she acted outside the standard of care. And she submitted to this board for consideration a document that says she lost her license for recommending a safe alternative treatment to a couple of fake patients for being drunk on one foolish occasion. And during the hearing to demonstrate rehabilitation, Ms. Binzer testified that she kept abreast of developments in medicine. She testified that she completed 8.75 hours of continuing medical education, but surprisingly, says this is likely more than she would have done if she was currently licensed. Ms. Binzer testified she's not in need of education because medicine hasn't changed significantly. The poor judgment displayed in her attitude in this statement alone speaks to the fact that she doesn't possess the judgment necessary to be entrusted to practice medicine. And despite the fact that Ms. Binzer drank to a point of being severely intoxicated and put people at danger, she can't see that her own self-diagnosis is not enough to ensure this board or the public that she's safe. If she doesn't see that she as a clinician shouldn't be judging her own condition and should let somebody independently do that, and that's what's necessary, that again speaks to her judgment.
Ms. Saunders, you have 1 minute.
Thank you, Your Honor. So while time has passed since Ms. Binzer was first disciplined, it doesn't seem her attitude, judgment, or skill has. After evaluating Ms. Binzer's conduct again, we've once again determined that the public needs for this board to protect the citizens of this state from physicians who are not adequately trained, who knowingly engage in practicing medicine below the standard of care, who do not take responsibility for their actions, and who are unable to ensure public safety. In this case, Ms. Binzer has failed to demonstrate by clear and convincing evidence to a reasonable certainty that she is rehabilitated. If the board is reconsidering its decision after non-adoption and is to make any change to that decision, the people recommend that it be denial of the petition for reinstatement. However, the board is...
Thank you, Ms. Saunders. You have 5 minutes to respond.
This attorney keeps repeating falsehoods, stating that I blame everyone except myself. I haven't taken responsibility for my actions. Those 2 statements are false. I never stated that medicine hasn't changed. Of course it changes, and I've been keeping up since the December meeting. I started getting free journals again in the mail, been reading those as often as they come in, and like before, listening to podcasts on Medscape and other websites. That 1 year that I worked with Medicam was extremely atypical of the rest of the 28 years that I've been in practice, and they were exemplary years of practice. There's no evidence of their not being exemplary. At the hearing, Dr. Ruiz was going to be a witness, however, he was ill that day. Not having an attorney put me at a disadvantage of not realizing the importance of coming with witnesses and coming with statements from other people. financial status, that's why I asked for the board's reconsideration. If you are putting a condition of relicensing a $10,000 course, I wouldn't be able to pay for that now as I wasn't able to pay for it in December. And I don't feel like my financial situation should be a bearing on whether or not my license is reinstated.
Brief reply.
Thank you, Your Honor. First of all, should this board like to look at the testimony that was reviewed, Ms. Spencer indicates that she didn't say that medicine hadn't changed. It's at the reporter's transcript, page 26, line 22, and page 28, line 14. With respect to the financial burden that this places on Ms. Spencer, I have yet to see a doctor talk to me about settlement and about a clinical training program that doesn't balk at the cost and say that it's a hardship. But a financial hardship to one individual certainly doesn't outweigh the harm that can be caused to members of the public should somebody be reinstated without the proper training, knowledge, and skill to adequately be a physician and surgeon. I can't emphasize that enough. 4 months ago, this board decided what they thought at that time, based on the record, was necessary. And I urge this board that if they do choose to reinstate that they do choose to grant the reinstatement, that those conditions be considered, and nothing has changed since that time that would indicate there's no need for those conditions. Quite frankly, it's been a long time since Ms. Spencer's practiced, and prior to being on probation, she wasn't practicing adequately and within the standard of care. That's how we got here. That's how this started. And as far as the driving under the influence, I can appreciate the fact that Ms. Spencer believes that that was just one incident. It wasn't just one incident. It was one incident that could have harmed numerous people. It was also a violation of the probation that she was on at that time, and was a demonstration of her inability to respect the rules and regulations set forth by this board in the first place. It brings to mind the question of what's to make anything different now? Should Ms. Spencer be reinstated? What's to make her respect the rules and regulations set by this board now? The people urge that reinstatement be denied, but do strongly recommend that if it is, that the conditions set forth in the decision after non-adoption still be applicable to any reinstatement at this time. Thank you.
A question from panel members. Dr. Yip? Dr. Bishop?
No.
Dr. Lewis?
No.
Ms. Wright?
Yes. I'm going to make a statement to you, and it's sort of 2 parts, okay? This this panel's not shallow to say that financial condition is going to be the reason that we're not going to do something. Also, medical board is tasked with public protection. So I found it concerning that you said something to the effect of like, I'm going to tell you, panel, what is better for public protection. So statements like that probably aren't a good idea when you get before us. And I'm saying that so it's generally being heard. But I'm going to extend you a quick lifeline, okay? Why do you think we put you on probation? Or why do you think you were placed on probation? And I want you, we're going to have a dialogue here because I have 2 follow-up questions.
Originally, I was put on probation because I was giving out medical marijuana recommendations without doing complete physical exams or waiting for records.
Do you think that your conduct fell below the standard of care?
Yes.
Okay. So are you remorseful?
Yes.
And what have you done to demonstrate rehabilitation up until this point?
I only worked for that company for a year. It was a decision that I made based on personal reasons. I did not have enough time to spend with my children, and getting that job allowed me to work only about 15, 20 hours a week and still make enough money to support myself and my 4 kids. And they needed more time with their mother at that time. After I started working with them.
Maybe I should have asked it a different way. what have you done to demonstrate rehabilitation? Because you're asking us to reconsider something, so I want to hear from you, what have you done?
I returned to the practice of medicine with a high standard of care. And all the clinics that I worked at subsequent to Medican, I have provided excellent care, taking proper history, physicals.
And a third person has certified that?
Pardon?
A third party other than yourself has certified that?
They can. I did
In
not
the record.
come prepared.
And I'm not trying to be harsh with you, and I don't want that to reflect that. But what I do, understanding that you're not represented by counsel, I'm almost asking you sort of leading questions for you to tell us why what you're asking us to do should happen. So what I want to hear from you, and you said you were remorseful, and I appreciate that. I want to hear the rehabilitation that shows that you will be safe enough for you to go back into practice.
I don't
For the people of
know what
California.
there was to rehabilitate. I worked with Medican for 1 year and I practiced substandard medicine care because of the way the clinics were set up. I left that and I haven't returned to that. I have had no complaints from any patients. I was in a practice doing well at the time of my revocation. When I was on probation, there was no problems with all my quarterly visits from the probation monitor. I rehabilitated by leaving Medican. I don't know what else there was to rehabilitate. I had one episode of drinking to the point of a blackout. One episode of my life. I don't know how to rehabilitate that other than returning to not drinking. I never drank much in the first place. I drank 3 martinis one time in my life, had an alcoholic blackout, and acted poorly. I realized that was a horrible thing to do, but I wasn't like I drank to excess and decided to get in the car and drive. I had a blackout. I wish that had never happened. It's a horrible feeling to lose 6 hours of your life. I never have regained any memory of those 6 hours. So to rehabilitate that, I returned to my regular state of drinking, which is rare. So again, I'm asked, I don't know what there was to rehabilitate, and the fact that I haven't seen a psychiatrist to say that I don't have a drinking problem is kind of silly, since you have to drink to have a drinking problem. There's no evidence that I drink. I have had one episode in my entire life of a bad experience with alcohol. That's it. There's no evidence to suggest that I have a drinking problem.
That led to a blackout?
I had, pardon?
That led to a blackout?
One time, yes, and there's evidence that I presented prior that most people that have blackouts do not have a problem with alcohol abuse. The majority of people that have a blackout have it because they ingested too much alcohol over a short period of time on an empty stomach. And it is not indicative of a problem with alcohol like most people think.
Dr. Hawkins?
So Ms. Benzor, you've heard public protection's primary multiple times, and it really is true.
Yes.
We have essentially 2 options as I see it. One option is for you to stay in your current state as a non-licensed physician, non-licensed person to practice medicine. You can't practice medicine. Second option is to accept your license reinstatement terms and conditions. We don't have a third option. There's no hybrid. My question is, which one do you want?
Why is it that only those 2 options exist when I've seen a physician who had a blood alcohol level higher than mine and acted worse than I did, got a letter of public reprimand? Why are those the only 2 options that I have when you have given a different physician who was in the same situation as I a letter of public reprimand without any other conditions?
Each physician is evaluated individually. As I see it, you have two options, and you should tell us what you really want. Do you want to stay where you are as of
No,
now?
I want
Or
to
do you want-
return to the practice of medicine, but my financial, there is no way that I can afford $10,000 for a course.
Just
If I
answer, please
could-
answer the question. Do you want your license back?
Yes, I do.
Will you accept the terms and conditions?
Yes.
Forget about the money for now.
Yes, I will.
Thank you.
Mr. Warnock?
No questions.
All right, and that concludes the open portion of this meeting. If you would all leave so the